Hi, I'm Jeff McDonald from the law offices of Hassett and George. I wanted to talk today about social media and how developments that we're seeing in social media with our practice, with our insurance defense practice. There's not a case in my office where I don't use social media, whether it's Facebook or Twitter or Snapchat or Instagram. Whenever we get a file, we'll look at those different platforms and to see if we can discover any information regarding a plaintiff. It's amazing what we do find. Plaintiffs will post about the accident or the subject matter of the complaint. They'll also post photographs or videos that may contradict some of the injury claims that they're making. So it's something that we utilize regularly. Because this is sort of a new platform, we're seeing the courts just starting to catch up to it and just starting to deal with social media and Facebook. And one case I wanted to talk about today is State versus Bull. It's a Supreme Court case, came out just 2 months ago in June, and it dealt with criminal charges, but the claims against that defendant were that he had publicly published photographs onto Facebook, and it was a violation of one or another criminal statute. That's not important. The important part is what happened in that case was the trial court and the appellate court found that the state didn't establish that the photographs that were uploaded onto Facebook were published publicly. They said that you needed to have an expert witness in order to establish that this was done in a public domain, and because the state didn't present an expert witness, then that information wasn't enough to allow for a conviction. Our Supreme Court just recently ruled that expert testimony, in fact, wasn't required to determine that this was public. And what the Supreme Court said and why it's important is they looked at Facebook and they cited a study that had a percentage of Americans that use Facebook. And it was so high, it was 72%, that they determined that it's not something that requires expert testimony, that the average common juror, it's not beyond their experience or their knowledge that you'd need expert testimony. So the importance that we draw from that case is, in our cases, beyond the criminal context, is that the information that we're trying to use, whether it be photographs or posts that we're trying to maybe introduce later on at trial, we're seeing the court trend toward recognizing social media, recognizing Facebook, and recognizing the fact that we may not need expert witnesses to try and establish IP addresses or date stamps as to when this information was posted. So we think that State versus Buell and other cases that will continue to come along will continue to soften the stance on social media, and will continue to make things a little easier for us in how we introduce the information that we glean when we're dealing with these insurance defense cases. So that's what we think is coming down the pike. It's a good decision. It's helpful for our practice. And if anyone would like to discuss this case further or any issues that we see with social media in our insurance practice group, we'd be happy to have those conversations. Or you can check out our website.